When there's a vacancy, the president pretty much determines who he or wants to appoint. Legally speaking, constitutionally speaking, the same process is used for all federal judges, but in fact they're very different. Supreme Court appointments have become high politics. We assume that there is a kind of stage that's going to be lit up. Why? Well, and this, I'd say, this what I call the new politics of Supreme Court appointments really goes back to the 1960s, when Justice Abe Fortas, who had been nominated by Lyndon Johnson to be the new Chief Justice, was filibustered by a young group of Republicans, and he left. He withdrew, and then the next year he left the court under an ethical cloud, and that began a series of paybacks. And if you look at a series of judicial appointments and confirmations in the ensuing years, each party is saying we're going to pay back. Payback is a real thing in Washington. If you ask some of the Republican senators who voted against Sotomayor, even though they agreed that she was very qualified, the fact is they said, well, but we're very bothered because Barack Obama voted against John Roberts and Samuel Alito. And I think, therefore, this kind of payback dynamic is going to keep going for a long time. But I think everybody recognizes now that Supreme Court appointments they're higher stakes. The court's importance in the political system is now much more widely recognized than it had been before. And so the process has become more adversarial, more confrontational. The language is crude and coarse. The fact is, it's just like the rest of American politics, just like Hillary the movie, or something like that. Ironically, it's also more democratic. That is to say, more people are involved, and in some sense, the confirmation is a kind of national referendum. And this is the case both at the nomination and the confirmation stage. Nobody can believe that a president would make a Supreme Court appointment without carefully considering ideology, which has now become central, with one exception. In fact, ideology was probably one of the two most important factors in the Sotomayor appointment and in the way in which the Senate treated it. And the other is partisanship. If you ask a lot of, or just look at the record, you see that there are a lot of Southern senators and Republicans, not only Southern senators, but Republicans who voted against her, even though they said nice things about her. 50 years ago, they would have all basically criticized her for the record and then voted for her or stayed out of it. That's what Lindsey Graham did, the Republican senator from South Carolina. He said, she wouldn't have been my appointment, but she's really very well qualified, and Barack Obama won the election. And therefore, he's entitled to his choices. But not many people agreed, because there was a tremendous amount of political pressure by Republicans to show strength. And not because they thought they could defeat Sotomayor, because they knew they couldn't, because the Democrats had the votes, but because they were girding themselves for the next Supreme Court appointment. And the next one after that President Obama might make, which suggests, of course, that confirmation battles are often not about the individual nominee, but about the process and about the president. A lot of the opposition to Robert Bork was about him, but a lot was also about Ronald Reagan. That also suffered from one of the facts that everybody has noted, which is that presidents have less success with their judicial appointments in the last years of their term than in the beginning. This was Obama's first year. That was Reagan's 7th year when he appointed Robert Bork. And I think that made some difference. So I think we could say that this process has become highly political, highly partisan in both the best and worst senses of the word. And of course there are many critics, and if you have criticism, you want to ask questions, by all means do so. People who like to change the process, maybe don't televise it, that seems to be impossible to me. Perhaps change the practice of the justices, of the nominees appearing personally, because when they appear, all they do is say things that everybody knows aren't true. That it's kind of a charade that everybody plays. Both Democrats and Republicans, Roberts and Alito and Sotomayor, did exactly the same thing. Roberts was particularly adept at doing that. I remember when we were talking with my class about that, and Roberts was asked a standard question about Roe versus Wade, and he, of course, was not going to answer the question of how he would vote on Roe versus Wade, although I think everybody assumed he was probably not a supporter. And then he said something that made the headlines the next day, and I brought in that newspaper and I showed it to my class. It says, Roe versus Wade is entitled to the respect of precedent. I'm sorry, the precedent of Roe versus Wade is entitled to respect. And I said to my class, what the hell does that mean? Because it doesn't mean anything. Because on the Supreme Court, precedents are not ironclad, they're simply guidelines, rules of thumb. Anybody know what the rule of thumb means, by the way, where it comes from? It's a famous expression in English law. You won't like it when I tell you. Anybody?
You can't beat your wife.
That's correct. The rule of thumb was the English rule about the width of the switch that a man could use to beat his wife. You think about that one for a while. So what we have, therefore, is a process that tends to push all nominees a little bit toward the center. I think that Roberts and Sotomayor and some of the other names that were bandied about for both of those vacancies are clearly people who were good lawyers, who were smart, who were well trained, and they were not likely to really make things move very differently. Robert Bork, actually, I give him credit, though I certainly didn't support him, but I give him credit because he actually tried to say something intelligent, and it backfired. Robert Bork, who of course had already pretty much told people that he was the most deserving candidate for the Supreme Court, but was a very committed conservative, but I think everybody agrees a man of extraordinary intelligence. He had been a great law professor at Yale Law School, though not of constitutional law, but of antitrust. And he'd been a socialist as a young man and then moved across the political spectrum. In any case, he decided to use the hearings to explain to the senators and to the public why the constitutional right to privacy was illegitimate. And he failed totally. And it probably defeated his nomination because, number one, the technical aspects of the case called Griswold versus Connecticut were beyond most people. And second of all, most Americans liked their privacy. And they didn't like the idea of a judge-to-be telling them that they couldn't have it. He, by the way, also made another terrible mistake. He was advised to get a haircut and cut his beard off. He had a pirate kind of red beard and a lot of fuzzy hair that I could wish I had. But anyway, he looked fierce. And on television, that really did hurt. I mean, people just couldn't kind of identify with it. In any case, so that's how Sotomayor became a justice. What difference will it make? Now we get into real stuff. Remember that the court has been divided for some time, essentially 5-4, with 4 conservative justices, 4, I'll call them more liberal justices, because none of them is as liberal as Brennan or Marshall, but they're more liberal, and 1 justice, a kind of swing justice, Anthony Kennedy. In fact, in the last term of the court, just ended in June, the court decided 23 5-4 cases, and he was in the majority in every case.